Swayam Prabha. Digital India. Educated India.
Hello all. In continuation to our previous discussion regarding the IP licensing and the Indian competition law, in the previous class we have dealt with the jurisdictional issues which has been raised by different cases, like whether CCI, Competition Commission of India, is having the power to deal with the IP licensing cases or not. So, as we saw in the Micromax case and the other case, where it has been proved that yes, CCI has the power to deal with the IP licensing cases. Now, coming next is the today in this module we will deal with the IP licensing cases, but and like strict IP licensing cases and how it has been dealt by the Indian competition law. So, in this module we will particularly focus on few cases, particularly the Samser Kataria case, then ATOs versus Verifone case, then Just Ticket versus the Big Tree, and the K Serasera case. So, this case will give us a brief idea how the different aspects in a IP licensing agreement can create certain anti-competitive environment and how the Competition Commission of India is dealing with such problems. So, moving forward, let us take the first case. So, this case is basically between Samser Kataria and the automobile players like Honda, Volkswagen, Fiat and other major players in the automobile sector. This is one of the important case in the sector of the private automobile industry, where the monopoly or the monopolistic power of these private vehicle companies were questioned by Samser Kataria. So, basically Samser Kataria alleged that the companies like Honda, Volkswagen or the Fiat, which are the branded car companies, particularly personal vehicle company, are creating a monopolistic environment in the automobile segment of India. Basically, the Samser Kataria alleged that these companies are creating a monopoly over the supply of the genuine spare parts and particularly their repairing and the maintenance services. And basically they are creating this monopolistic or the restrictive environment by restricting the sales and supply of the genuine spare parts and their diagnostic tools or the various equipment which are required for the servicing of the vehicles, and also they are not providing the technical information required for the maintenance, service and the repair of the vehicles to the other unauthorized or the private car repairing services centers. So, according to the informants, that is Samser Kataria, basically by all these alleged anti-competitive practices, the companies like Honda, Volkswagen and Fiat are taking higher charges for the maintenance of the vehicles as well as, and they are certainly indirectly determining the prices of the spare parts as well as the maintaining or the repairing services. Further, the informant Samser Kataria alleged that these restrictive practices, by not supplying the genuine spare parts or the information regarding the servicing of the vehicles, the company or the opposition parties in related to this case and like they are type of denying the market access to the independent repair workshop. So, basically there are two segments like this, the companies which are the original equipment manufacturers, we may call it OEM, and there are authorized servicing center by this company, which we make termed as the original supply companies. So, now by denying the other independent repairing workshop which are not the authorized dealers from these companies, the companies has created a kind of restricted environment, and they are denying the market access to the private players or the small players basically in the Indian market. And for that reason, the informant has stated that the cost of getting a car repaired in an independent workshop is generally cheaper than 35 to 50% as compared to the authorized service centers. For the reason that the authorized service centers, since they are the only source getting the supplies in terms of the equipments as well as the services from the original equipment manufacturers, they charge higher prices. But when the in that case they cited the example of the Maruti Suzuki car. So, where because Maruti Suzuki had given the access to his spare parts or the other servicing requirements to private players. So, a person can easily in a cheaper price can get the car repaired or serviced in a private repairing station. But in these cases, particularly Honda, Volkswagen and the Fiat, like in those cases, like getting a car repaired or serviced cost more than 35 to 50% approximately. Further, in this case, Samsher Kataria also cited the examples in European Union and US, how the automobile sector, creation of a competitive environment in the automobile sector has been given a priority in the European Union as well as the United States. Like the TTBER had given certain exemption or mentioned the criteria under which the automobile companies can give access to their spare parts or this techniques, as well as in some of the states of the US has enacted the Right to Repair Act, which curbs the restrictive practices by the automobile manufacturer. So, to basic aim of this complaint was to just bring to the notice of Competition Commission of India that these private players like Honda, Volkswagen and Fiat are creating a monopolistic as well as restrictive environment by denying the access to the spare parts as well as the servicing service to the other private players. Now, so in this case, the informant has asked for relief he requested to hold an inquiry into the trade practices of the respondent and any other vehicle manufacturers, their authorized dealers at the servicing centers which are indulged in a similar activity, and to give a finding that such parties have committed restrictive and unrestrictive or unfair trade practices in contravention to the Act. And also they have requested CCI to order a cease and desist from such restrictive and unfair and monopolistic trade practices. And they claimed that the companies are having a dominant position and they are misusing their power and or abuse of dominant position is there. So, again they have also requested to pass appropriate direction for the respondents, and they should they should ask the respondents to supply the genuine spare parts or the servicing manuals to make or ask them to make it freely available in the open Indian aftermarket. So, taking the cognizance of this case, the Competition Commission of India had made a prima facie opinion that yes, in this order it seemed that there is certain something is not clear, and they passed an order in 2011 saying that asking the Director General to conduct an investigation into this matter. As we know, the procedure in the last class we discussed procedure for investigating into a matter. So, after a prima facie case has been established, the Competition Commission of India asked Director General to investigate into this matter, and meanwhile it also sought report from the respondents like whether there should be an investigation or not, and after getting these two reports, then the commission gives its decision. So, So, the investigation into the matter it showed that the respondents like the Honda, Volkswagen and the Fiat, apart from these three respondents which are named in this thing, the Director General found that there may be some other companies in the Indian automobile sector which are also involved in some such kind of the restrictive practices in the areas of after sales service, procurement or the sales of the spare parts from the original equipment suppliers, and setting of the dealerships. Because in most of these cases private most of these automobile manufacturers did not allow the private or third party repairers or the servicing station to sell their original spare parts and other materials required for the maintenance and the servicing of the vehicles. So, this case involved the larger issue that there is a prevalence of anti-competitive conduct, and it is basically having a larger effect or making a larger effect to the Indian consumer, because the automobile sector is one of the biggest industrial sector in India. So many like the number of people using cars are increasing day by day, and since the maintenance or the servicing cost is very high, so it is basically affecting the consumer at large. So, it was proposed by Director General that there should be an investigation, and the anti-competitive trade practices must be investigated for all the car manufacturers of India which are maintained by the Society of Indian Automobile Manufacturers. So, not only these three companies which are named in this case, but there should be investigation against all the car manufacturers company which are the part of the SIAM or the Car Manufacturing Association. So, while dealing with the case, so like any other anti-competitive practices cases, like first the Competition Commission of India tried to find out what is the relevant product market in this case and what is the geographical area in which the case can be dealt with. So, in this case there were two separate markets were identified for the passenger vehicle sector. First is the primary market, which is basically the manufacturing and the sales of the passenger vehicles, means direct sales of the cars to the passenger, and second one is the which is known as secondary market, which is otherwise known as the after market. So, according to the Director General's report, the after markets are basically the markets for the spare parts, the diagnostic tools and the other technical manuals and after sales repair and maintenance services that are generally required after the car has been purchased by a consumer, or after the primary buying of the primary product. So, primary market and secondary market. So, there can be two relevant product markets sector in this case. And further, the Director General had classified these aftermarket segment into two subsections. They are first the supply of the spare parts which included the diagnostic tools, technical manuals, catalogs and other things which are required for the aftermarket usage, and the second subsection was the provision of after sale services, which includes the servicing of the vehicles and maintenance and other repairing services. If some accident or normal repairing servicing is required by the vehicle, then those things necessary for the servicing of the vehicle is coming under the purview of this after sales services. So, there were two subsections for this aftermarket. Now, then the next important criteria to investigate into any case was to find out what is the relevant geographical market. So, so the DG noted that like whenever a person buys a car from any brand, then so he can buy the car from any state of the India, and the spare parts for those particular cars, those brand of cars are available in all the states. So, it is not necessary that if a person buys a car from some certain state, he has to repair it or get the spare parts from that states only. So, again, the car can also be repaired or serviced in any of the states also. So, therefore, in this case the relevant geographical market was identified to be the whole country of India. So, there were so the two main criteria identification were done. First, which are the relevant product segment. So, there were two market segment. The primary is the original equipment or the car itself, then the aftermarket, which includes the spare parts and other technical manuals which are necessary for repairing or maintaining the vehicle after the sales, and India was considered to be the relevant geographical market. Even though these car companies like sometimes are not particularly located in India also, in that case also, since the products are sold in India, so it was the relevant geographical market in this case. So, first let us discuss about the Director General's finding regarding the dominance of this original equipment manufacturers in the market for the supply of spare parts. So, anyway, like because the cars are coming from a definite brand, so these are the like main player who are selling them. So, in the primary market there is no doubt that they are the dominant player, but in order to understand their dominance in the spare parts sector, the DG has further investigated, and they found that these each of these original equipment manufacturer or the branded car companies is a monopolistic enterprise or dominant player in the relevant market of the supply of spare parts. Not only spare parts, the other diagnostic tools, technical manuals, software, etc., which are required for the maintenance and the repairing of the vehicle. Because apart from these original manufacturers, there were no other source from where a consumer can get the required repairing or the servicing equipments. So, for that reason it is considered that the original car companies or the original equipment manufacturers are having a monopolistic or dominant position. And the Director General concluded that the spare parts, diagnostic tools and manual etc. Of each of these original equipment manufacturers would constitute an essential facility for the independent repairers. So, in order to define or in order to label something as an essential facility, they have also taken taken some essential factors to see that whether this can be termed as the essential facility or not. So, basically they have looked into 4 factors like before like can a spare parts provider or a spare part manufacturer can a spare parts be itself be termed as the essential facility or not. So, basically 4 questions were looked into. First, like the control of the essential facility by the monopolist or the original equipment manufacturer. So, is there any alternate source available apart from the original equipment manufacturer for the spare part? The inability to duplicate the facility. Is there any other company who can duplicate the same spare part which will fit into that car or the vehicle? Third, the denial of the use of this facility. So, can a consumer deny that I do not want to use this spare parts, I will use a different spare parts, like is there any alternate provision available? And the feasibility of providing the facility. So, is there any chances that any other supplier or the spare part manufacturers can fill the gap or supply the same thing without the original equipment manufacturer's help? So, these things were taken into consideration, and from there the Director General concluded that the diagnostic tools, the manuals, the technical manuals, everything are constituting the essential facility for independent repairers. So, if the independent repairers are not getting those essential facility, they cannot repair or provide service to any of this vehicle. So, now the dominance has been established, the relevant product market has been established, the relevant geographical market has been established. Now, it has also been proved that those things are essential facility. Now, the Director General looked into the matter that like the refusal to provide certain such essential facility, the implications of refusing to provide certain essential facility. So, it was contended by the original equipment manufacturers or the spare part manufacturers that the original equipment suppliers are having certain IPRs. There are certain IPRs involved, intellectual property rights are involved. For that reason, the IPR, for that reason the original equipment suppliers basically cannot share those things with the third party. They need to have a consent from the original equipment manufacturers in order to sell the or give the product to any third party, So, because they like they contended that the opposite party, the respondents contended that the spare parts are manufactured by the original equipment supplier based on the designs, drawings or the technical specification, technology know-hows which were provided by the original equipment manufacturer. So, basically the original equipment manufacturer or the companies are having certain intellectual property rights. So, there is a technology transfer agreement between the branded company to the original equipment supplier, and for that reason they are being prevented to share those equipments or the tools to any third party. And they also claimed the exemptions on account of this copyright protection for the engineering drawings as well as the various technical manuals. So, since the technical manuals and the engineering drawings are a part of literary work and it is protected by the copyright. So, under this copyright provision as well as the Patents Act and Designs Act, so they claimed exemption and they express their inability to share the things with any third party. So, after this the OEMs further relied on that the exemption provided in the subsection 5 of section 3, like we just discussed in the earlier class that the exemptions are generally taken as a blanket exemption by the dominant player, but similarly in this case also they cited this section subsection 5 of section 3 as an immunity from sharing or sharing the IP or as a ground for giving reasonable restrictions to enjoy their monopolistic powers. So, in this case the Competition Commission has thought of considering two issues. First, whether the right which is put forward by the original equipment manufacturers is correctly categorized as protecting an intellectual property, and whether the requirements of the law granting the IPRs are in fact being satisfied or not. So, they tried to investigate into these two questions. So, they have asked the original equipment manufacturers to provide the necessary information regarding the intellectual property right which they are claiming to have with them. So, basically it was found that the original equipment manufacturers could not provide any relevant documentation regarding their intellectual property right in India. As we know, patents right or designs or copyright are jurisdictional based or territory based rights. So, if a person is applying a patent in India, so he can claim his rights in India only. So, in this case like the original none of the original equipment manufacturers could provide the patent or the any other IP related information which can be made applicable to India. So, further they found that even though the parent corporation of this original equipment manufacturers are having certain rights in other territories, but since it is again territory based, these rights cannot be extrapolated to India or they cannot claim of having those rights in India. And by mere entering into a technology transfer agreement from the parent company to the suppliers in India, it does not render it to think that they are having the intellectual property right in India also. So, the ground on which the respondents are arguing that they are putting the reasonable restriction, or they cannot supply the things to the third party, were proved to be wrong. Again, then further CCI decided on whether these original equipment manufacturers claim over the IPR exemption passes the reasonability test as ingrained in the section 3 subsection 5 I of the Act. So, basically the CCI looked at, can the IPR holder be able to protect his IPR even if such restriction was not present. So, even like if there was no restriction to supply to the third party, can the IPR be prevented or the protected or not. So, CCI looked into that in that direction. So, basically the selling of the finished products like the bumper or the hoods or the bonnets, which may be which may need repairing, or the fog lights etc., which are used in the cars, in like selling of those things in the open market does not necessarily comprises such IPR, because the intellectual property which are like the intellectual property which the companies are having can be just protected by any technology licensing agreement. So, so in this case, if the original equipment manufacturers allows the original equipment suppliers to sell the finished products to third party, then also there is no violation of the IP, even if some IP existed. So, in that questions also, the ground on which the respondents were claiming immunity were found to be baseless. So, for that reason it was proved that the branded company Honda, Fiat or the Volkswagen, they have they were behaving the monopolistic, they are showing the monopolistic nature, and giving the providing conditions for restricted trade in the automobile sector. And finally, the Competition Commission of the India directed the original equipment manufacturers to allow the original equipment suppliers to sell the spare parts in the open market. Means now the third party can get the spare parts from the original equipment supplier and use it for their own business. And in cases where the original equipment manufacturers held certain IPRs on some parts, which is parts of the car, the CCI allowed the original equipment manufacturers to charge certain minimum royalty or the fees through the contracts of the such part. So, the IP can be protected via the agreement, and if it is having certain intellectual property, then they can claim certain royalty or fees on them. But however, Competition Commission of India did not decide what will be the quantum of this royalty or what will be the exact amount of this royalty, because it is not a price fixing authority. So, it just provided a remedy by which the problem can be solved, and the private servicing provider can get the spare parts or the tools from the original equipment supplier. So, this is one of the important case which like showed, like IPR per se, like having just having an IPR does not mean that you can put any clause, or you can claim that your behavior is not anti-competitive. IPR, so the exemptions provided under the section 3 subsection 5 is basically to just to prevent the infringement. You can, without infringement, how you are enjoying your intellectual property right, but it does not mean that you can put any restriction which you want. So, reasonable restriction under necessary condition can be placed, not like that. So, that was one of the important cases which like dealt in the IP aspect. Even in that case also, it is not proved that all the things which they are like all these technical manual or drawings or tools can be protected via IPR, like patent or any other forms of the IPR. But anyway, the commission did not dealt into that detail, just the basic thing that mere having an IP does not stop to supply the things which are the essential facilities to the third parties. In one of the similar lines, there was another case which is the Atos World Line India Private Limited versus the Verifone India Sales Private Limited. So, in this case, the Atos was a third party processor which tracked the flow of the intervening events between a card holder swiping his card and finally receiving the printing charge slip at the point of sales. Now, when we goes to any shopping mall, so now we can easily use our card, debit card or credit card, and in turn it gives us a receipt saying that this much money has been spent. So, basically it was the third party processor, and the other company Verifone was a supplier of this point of sales terminal along with the software development kit or the SDK, which enabled the POS terminals to function. So, basically Verifone supplied the POS terminal along with the software which enables the third party processor to function. So, in that case what happened? The ATOs alleged that the Verifone has abused its dominant position through restrictive and unfair conditions. Basically through this SDK agreement, the draft SDK agreement, with it, it required a purpose clause which provided that if there was a restriction on the licensee to use any third party information for the development of the application. So, basically the application did not allow the third party to develop any other application. And further it was observed that the license restriction clause relating to the disclosure mentioned in the SDK agreement imposes 3 different disclosure requirement. So, in that the licensee has to disclose the licensor from time to time the activities related to the licensed software, means whatever activity he has done with the licensed software. Second, it has to reveal what value added software it has created. Third, it has to also think like what was its intent to create using that software. So, everything it has to reveal to the licensor under this purpose clause. So, therefore, the ATOs has complained to CCI like it is a kind of like unfair trade practices. So, in this case the CCI observed that the purpose clause restricted the licenses to develop the value added software and use the same on only those of the licensor product that licensee has purchased directly from the licensor. So, it one way has restricted the licenses activity. Thus, the Competition Commission was found that the SDK agreement was restrictive as well as the anti-competitive. So, the Commission is of the opinion that through this SDK agreement, the Verifone has imposed unfair conditions on the value added services or the third party provider, service provider, which is in contravention of the section 4, the abuse of dominant position, section 4 subsection 2 of this act. And it also restricted the provision of the value added services as well as the restricted the technical and scientific development in this value added services segment. And the conduct of the Verifone with respect to seeking the disclosure of sensitive business information, I mean, for how many value added services you have developed, for what purpose you have developed, what are the consumer profiles and everything it was asking under this purpose clause. So, all these seeking measures were like so a kind of contravention in the for the as mentioned in the section 4.2, because revealing all the information in the downstream market is sometimes like may create a trouble for the licensing company. So, finally, the Competition Commission of India in this case issued a cease and desist order from indulging the activities which have been found to be in contravention of the section 4, and also it imposed a penalty at a rate of 5% of its annual turnover. The company had to give a fine of 5% of his annual turnover, the Verifone. So, in this case also like one cannot that the reasonable the restriction put by this the purpose clause or the SDK agreement, the restriction in this agreement were a kind of unnecessary restriction clauses. So, this is also not in contravention to section 4 of this Indian Competition Act. Similarly, in the next case like this Just Ticket Private Limited and the Big Tree Entertainment and Vista Entertainment, these are the basically two companies which are involved in the online ticketing system. So, the Just Ticket alleged the Big Tree, which is another online ticketing system and a distributor of the Vista program also. It alleged the Big Tree of abusing its dominant position by way of creating barriers for online movie ticketing portals and from getting access to the Vista API. So, basically the Vista API is the application programming interface which is created by Vista to enable the online ticketing portals to integrate with the Vista software for the data flow, data and the information flow, and it is necessary for like creating this online portal. So, it was submitted by Just Ticket that the Vista had an arbitrary policy of not to grant or access of Vista API, the application programming interface, to another online ticketing portal, and like it is a kind of denial to giving market access under the and in contravention to section 4 subsection 2 of this Indian Competition Act. So, in this case the Big Tree said that when a third party like the Just Ticket is asking to have this access to this API, so the Big Tree basically wanted to sign a non-disclosure agreement with the first informant, because with this non-disclosure agreement the Vista can protect its IPR. So, as a supplier of the Vista, the Big Tree Entertainment asked to sign a non-disclosure agreement and so this and since it has not denied the informant to it has not denied the informant from giving the Vista API, but it has asked for a non-disclosure agreement. So, basically what happens, in this case, when a company is having a certain competitive software, so both of them are having certain technical capabilities. So, by revealing all the information, it is possible that the licensing company can develop more powerful tool by using the same API which he has given as a license. So, so in this case, like the Vista was generally taking some time before it gave access to the relevant information. So, basically the access was provided for all the cinemas for at least for a lag time of 6 months, which is quite reasonable in this case. So, in this case the CCI prima facie determined that this case does not hold a ground, like it is not a violation of the section 4 subsection 2, and because the Big Tree and Vista has provided Just Ticket access to the Vista API. It is the fact that they asked them to sign this NDA which the Just Ticket did not want to sign. So, it is not a denial to access to the market. So, the case was dropped. And similar line, one of the important case was the K Sera Sera Digital Cinema and the Pen India and others. So, in this case the K Sera Sera, which is a digital cinema service provider which makes the movie into a compact digital form, it alleges that the opposite parties which are basically the producers or the presenters of the movies, all the parties have entered into a anti-competitive arrangement with the other opposite parties who are also digital cinema provider, with a view that like the case with a view that they will only provide the content of the movie to the other parties, opposite parties, like the the Pen India will sell the movie to the other parties and exclude K Sera Sera. So, all these company except K Sera Sera has entered into an anti-competitive agreement. In the response to this allegation, the Pen India as well as the other company revealed that they entered into such kind of agreement because they have a concern that if the movie is released to K Sera Sera, it may result into a copyright violation. So, in that regard they have submitted an evidence of a press release note. So, what has happened, it was held like in the earlier instances, it was held that the K Sera Sera was alleged of copyright violation for a movie produced by this Viacom 18. So earlier what had happened, so the Viacom 18 had developed an internal security mechanism in the form of a unique identifier for each copy of this movie. Before the movie is made into the digital content package, and it is distributed to the digital integrators in order to stop the online piracy and to identify the source of the leakage. So, one of its movie was leaked earlier. So, when the case was investigated, the Viacom 18 had revealed that the pirated copies of the movie had originated from the copy which he had given to K. Sarasara. So, basically K. Sarasara was accused for giving the copy for the piracy or for the software for the copyright violation of the digital cinema. So, for that reason they thought of excluding K. Sarasara from giving the digital cinema content. So, in this case the Competition Commission noted that the informant did not like the K. Sarasara did not refute the charges which is made against him, that piracy of this movie by Viacom 18, and the allegations made by the opposite parties are not baseless. It had certain substance in its allegation. So, the Competition Commission of India dismissed the case by holding that the decision of this opposite parties to refuse to exhibit their movie from the informant or the K. Sarasara's digital service, it is a kind of precautionary step to prevent any loss due to the piracy. So, it is the agreement or the so called anti-competitive agreement as alleged by K. Sarasara is not in contravention to section 3 of the Indian Competition Act. So, basically to as a precautionary measure they did not want to give their digital cinema content to K. Sarasara. So, this is not violation of the section 3 of the Indian Competition Act. So, all these cases gives us an insight how the Competition Commission is dealing with different aspects of the intellectual property licensing. So, the reasonable restriction made in a licensing agreement, whether it is necessary or reasonable. So, the Competition Commission of the India in each case individual, depending on the merit of the cases, tries to find out the reasonable conditions or the necessity of the restrictions, so that the agreement cannot be termed as an anti-competitive agreement. And in cases where it has found to be anti-competitive, CCI has given penalty or tried to modify the agreement or given applicable directions to the parties involved. So, these are few examples. In next few classes we will also deal into some more interesting cases. So, thank you for watching this video.